Margaret Calloway sat in the back of the courtroom on a cold Tuesday morning in March. She wore a plain gray coat. Her hair was pulled back simply. She carried a large brown folder under her arm, stuffed with papers that she had organized herself, carefully, over many months. Nobody in that room paid her any attention. And that was exactly the problem. The courtroom was full of people in expensive suits. Lawyers with leather briefcases. Legal assistants whispering to each other. Journalists with notebooks open on their laps. The case being tried that morning was a big one, a wrongful death lawsuit filed by 3 families against one of the largest construction companies in Illinois, a firm called Hartwell Construction Corporation. 3 men had died on Hartwell job sites over the past 4 years. 3 families had been left without fathers, husbands, and sons. And Hartwell's lawyers had spent a great deal of money making sure the world believed those deaths were simply terrible accidents, nothing more, nothing less. Margaret had spent the last 6 years believing otherwise. She was not a lawyer. She had never been to law school. She was a librarian, or at least, she had been one before everything changed. Now she was something harder to define. She was a mother, a widow, and a woman who had quietly taught herself things that most people never bother to learn. Her husband, Daniel Calloway, had been a construction foreman. A careful man. A man who checked and double-checked everything before asking his crew to step near it. He had been well liked at every job site he ever worked. His crew trusted him. His managers respected him. He came home every evening smelling of sawdust and coffee, and he always kissed his daughters on the top of their heads before sitting down to dinner. In October of 2013, Daniel did not come home. A piece of scaffolding on a Hartwell job site collapsed. Daniel fell. He did not survive. Margaret received a call that evening that she would never forget for as long as she lived. She remembered sitting on the kitchen floor because her legs stopped working the moment she heard the words. Her daughters, 14 and 11 at the time, had found her there. They had all cried together on that kitchen floor for a very long time. In the weeks that followed, Hartwell's legal team moved quickly. They told Margaret they were deeply sorry for her loss. They sent flowers. Then they sent lawyers. The lawyers explained that Daniel's death had been thoroughly investigated and that the company bore no fault. There had been an equipment failure, they said. A tragic, unforeseeable equipment failure. They offered Margaret a settlement. It was enough money to cover the mortgage for a few years and help with the girls' schooling. In exchange, she had to sign a document that prevented her from ever speaking publicly about what happened. Margaret had been in shock. She signed. For 2 years, she did what she was supposed to do. She grieved quietly. She went back to work at the library. She helped her daughters with their homework. She cooked dinner. She paid the bills. From the outside, she looked like a woman who had accepted her loss and moved on. On the inside, something was quietly burning. She could not stop thinking about a single detail, something Daniel had mentioned at dinner about 3 weeks before the accident. He had told her that he had flagged a problem with one of the scaffolding systems on the new job site. He had written it up and handed the report to his site manager. The manager had told him it was being dealt with. The official accident report that Hartwell later produced made no mention of any prior safety concern. There was no flagged report. No record of Daniel raising any issue at all. The company's story was that the scaffolding had met all safety standards and that the collapse was caused by an unusual combination of environmental factors. Margaret knew that was not true. Daniel had told her directly. She began reading. At first, she read everything she could find about construction safety regulations. She borrowed textbooks from the library where she worked. She read through federal workplace safety codes late at night at the kitchen table after her daughters went to sleep. She did not fully understand everything right away. She read the difficult parts twice. Then 3 times. She took notes. She made charts. She slowly began to understand how safety reports were supposed to work, who had to file them, where they had to be sent, how they were stored, and how they could be checked. Then she read about document law. About what it meant when a company altered a record. About something called metadata, the hidden information inside digital files that recorded when they were created, when they were changed, and who had accessed them. She took an online course in digital document forensics. It was run by a former investigator, and it was available for free. She worked through it over the course of 4 months. She did not tell anyone she was doing it. She simply studied. In the summer of 2017, something unexpected happened. A man she had never met sent her an anonymous message. He told her that he had worked at Hartwell for 9 years and that he could no longer stay quiet about what he knew. He told her that Daniel's report had existed. It had been filed properly. And it had been pulled from the official records by a site manager who was worried about delaying the project timeline. The original file, he said, had been altered, not deleted entirely, but changed. A digital copy still existed somewhere inside the company's archived contractor records. He told her the name of the system it was stored in and the rough timeframe when the change had been made. Margaret did not panic. She did not call a reporter. She did not call a lawyer. She sat down at her kitchen table and she started working. She filed a public records request. She cross-referenced contractor licensing records. She mapped out the document chain step by step. It took her 14 months. At the end of those 14 months, she had found the file. More than that, she had found the proof of what had been done to it. The metadata inside the document showed clearly that it had been accessed and modified by a named Hartwell employee 19 days after Daniel's accident. Before the modification, the file had contained a safety concern report. After the modification, it did not. She had not just found a clue. She had found a crime. She also found something else. While tracking the document chain, she came across records from other job site deaths connected to Hartwell. Not 1. Not 2. 4 other cases over a period of 8 years. Different families. Different states. Similar patterns. Safety reports that seemed to vanish. Accident investigations that concluded remarkably quickly. Settlements that came bundled with silence agreements. Margaret contacted those families. She wrote careful letters explaining who she was and what she had found. She did not exaggerate. She did not make promises. She simply told the truth and let the families decide what they wanted to do. 3 of them wrote back. Together, they found a legal aid organization willing to take on the case. The lawyers there were good, young, serious, and not afraid of a fight. But they were also overwhelmed. They had dozens of cases on their desks and not enough hours in the day. Margaret stepped in. She organized the evidence. She created binders for each family's case with clear indexes and cross-references. She identified the witnesses who would be most important. She flagged the specific safety code violations and matched them against federal case law so the lawyers could build arguments quickly. She prepared timeline documents. She drafted summaries. She kept everything clearly labeled and always up to date. She did this while working part-time at the library. She did this while raising her daughters. She did this while sleeping fewer hours than was probably healthy. She never complained. She never asked for credit. She just worked. Hartwell's legal team, led by an attorney named Brendan Harlow, learned about Margaret's involvement and were not worried. She was nobody. A librarian. A grieving widow. A woman with no law degree, no credentials, and no formal training of any kind. Harlow had beaten back far more dangerous opponents than her. He was wrong to be comfortable. On that cold Tuesday morning in March, Harlow called Margaret to the witness stand. She was not a plaintiff in the case, her own settlement agreement had prevented that. She had been subpoenaed as a hostile witness. Harlow's plan was straightforward. He was going to use her presence to make the entire case look ridiculous. He was going to show the court that the evidence they were relying on had been assembled not by legal professionals, but by an emotional, unqualified woman on a personal mission. He began the moment she sat down. He stood near the center of the room, where everyone could see him, and looked at her as though she were something mildly amusing. "You have no law degree," he said, not as a question. "No credentials. No formal legal training of any kind. Is that correct?" "That is correct," Margaret said. A small ripple of noise moved through the gallery. Harlow continued. He asked her whether she had ever passed the bar exam. She had not. He asked whether she had any academic qualifications in forensic document analysis. She did not. He asked whether she had ever worked inside a law firm, a court, a regulatory agency, or any government office connected to the law. She had not, and had not. With each question, the implication grew stronger. This woman had no business being here. The work she had done was amateur. The evidence she had assembled was unreliable. The case built on her work would fall apart the moment anyone looked closely enough. Then Harlow picked up a document from his table. He held it up. It was one of the key exhibits from the evidence binders Margaret had compiled. He told the judge that it contained an error, a mislabeled internal memo, and that this error demonstrated exactly the kind of sloppy, careless work one could expect from someone with no professional training. He said the word amateur again. He smiled slightly as he said it. He asked Margaret to explain how she had obtained the document and whether she was even capable of verifying its authenticity. She looked at him. She took one breath. "Yes," she said. "I can." She asked the judge if she could refer to exhibits already entered into evidence. The judge allowed it. She referenced 4 specific items from the binders, calmly, by exhibit number, as though she had done this 100 times, which in a sense she had, alone at her kitchen table. She explained that the document Harlow was holding had a digital history. She walked the court through what metadata was, in plain, simple language that everyone in the room could follow. She explained that every digital file carries hidden information about when it was created, when it was changed, and who had access to it. She told the court that she had used forensic tools, freely available and professionally established, to examine that history. Then she explained what the history showed. The document had been created on a Tuesday. It had been accessed by a named Hartwell employee 19 days after Daniel Calloway's death. After that access, the content of the file had changed. Specific sections that had previously existed, a safety concern report, flagged by a foreman 3 weeks before the accident, were no longer there. She gave the name of the employee. She gave the date and time of access. She gave the version numbers of the file before and after the change. The courtroom was silent. The judge leaned forward. Harlow's co-counsel reached across the table and touched his arm. Margaret continued. She referenced 2 more exhibits showing the same pattern from 2 other Hartwell cases in 2015 and 2016. The same type of files. The same type of changes. The same timeline, modifications made shortly after accidents, before the official investigations concluded. She was not loud. She was not dramatic. She did not perform or preach. She simply presented what she had found, clearly and precisely, the way she had always believed truth should be presented. When she finished, the room stayed quiet for a moment longer than was normal. Then the judge asked Harlow if he had any further questions for the witness. Harlow looked at his notes. He looked at the document in his hand. He set it down. "No further questions," he said. The trial continued for 6 more weeks. There were other witnesses. Other arguments. Other documents. But that Tuesday morning in March was the moment the case changed, and everyone in that room knew it. The jury reached a verdict in the spring. Hartwell Construction Corporation was found fully responsible. The 3 families were awarded a combined sum that was, at the time, among the largest wrongful death verdicts in the history of the state. 3 Hartwell executives faced federal charges for the falsification of official workplace safety records. Margaret's own settlement agreement was officially voided as part of the resulting legal process. For the first time in 6 years, she was free to speak about Daniel publicly. She gave one interview. It was short. She did not talk about the verdict or the money or the courtroom. She talked about Daniel. She talked about what he was like on Saturday mornings when he made breakfast. She talked about the way he always knew when one of the girls was having a hard day without being told. She talked about the sound of his voice when he said goodnight. The story was picked up by newspapers across the country. People read it and were moved, not by the legal victory, though that mattered too, but by the image of a woman who had quietly, stubbornly refused to let the truth disappear. A woman with no power, no title, and no credentials, who had simply decided that love was a good enough reason to keep going. Months later, Margaret went back to the library. It was an ordinary Wednesday afternoon. The shelves were exactly as she had left them. The same patrons sat in the same chairs. The same pale winter light came through the tall windows. She was straightening a row of books when a young woman walked in. She was perhaps 25, with dark circles under her eyes and a thick envelope in her hands. She stood in the middle of the room looking slightly lost until she found Margaret. "Someone told me you might be able to help," the young woman said. Her voice was careful and thin, the way a voice sounds when someone is trying hard not to cry. "My brother died on a job site last year. They're saying it was his fault. I don't believe them. But I don't know where to start." Margaret looked at her. She looked at the envelope in the young woman's hands. She walked over and pulled out the chair across from her own. "Sit down," she said gently. "Tell me about your brother. And then we'll start from the beginning."